Viewers, more than 5 years ago, India's capital was rocked by riots over the Citizenship Amendment Bill, which later became an act. Over 50 people lost their lives. Over 500 got injured. Hundreds of police personnel doing their duty got hurt in the scuffle between communities. 5 years from that deadly wave of violence, the alleged conspirators continue to remain behind bars. The Delhi High Court today rejected the bail plea of Umar Khalid, Sharjeel Imam and 7 others in the larger conspiracy case. Prima facie, the court observed that the duo, especially Umar Khalid and Sharjeel Imam, were architects behind this conspiracy. Times Now's accessed the stinging remarks made by the court in its order. The High Court has said that prima facie their role involved calling for protests and chakka jams to disrupt daily lives, delivering inflammatory speeches to provoke violence and creating WhatsApp groups and distributing pamphlets in Muslim-dominated areas to push them towards violence. On the larger issue that the accused have the right to bail due to delayed trial, the court observed that this rule is not universally applicable in all cases. It also reminded that the duty of courts is to balance individual rights and interests of the nation. A political slugfest now has broken out over the High Court verdict. A united opposition has collectively condemned the denial of bail to Umar Khalid and company, saying that it is a travesty of justice. The BJP says that Vipaksh and sympathizers have no trust even in the courts now.
गलत है, bail is a rule, not exception, but यहाँ तो bail deny करने का मतलब रूल के साथ में खिलवाड़ करना और धर्म के आधार पर ऐसा हो रहा है और मुझे मालूम है कि कितना दबाव है न्यायपालिका के ऊपर, सरकार का दबाव है।
आज फिर से कांग्रेस और उसके समर्थित इकोसिस्टम को झटका पड़ा है जब उमर खालिद, शर्जील इमाम सहित कई लोगों की बेल जो दिल्ली दंगों के मास्टरमाइंड रहे हैं वो रिजेक्ट की गई है दिल्ली हाईकोर्ट के द्वारा। ये दिखाता है कि ये दंगे जो हुए वो स्पॉन्टेनियस नहीं, वो स्पॉन्सर्ड थे। पर ये इकोसिस्टम, इसमें तृणमूल कांग्रेस भी है और हैरानी की बात है कि उद्धव सेना की प्रियंका चतुर्वेदी भी है, वो इन दंगाइयों को कवर फायर देते हैं।
Let's get a quick update from Bhavtosh Singh, who's joining us live. Bhavtosh, several stinging observations that have come in from the High Court, which in fact have countered all of the criticism that has been coming in for the court's way, because including several of the opposition leaders saying that it's a travesty of justice or that bail is the norm and jail is the exception, which has been ignored in this case. The High Court has clearly said that that is subjective and depends on the circumstances at hand. Bhavtosh, take us through what the High Court has said today.
Yes, Madhav, in fact, the order, which is 133 pages long, has gone through every aspect as far as this case is concerned, including the fact that there has been inordinate delay. The charges have not yet been framed. Importantly, it also covers a rather controversial part, is the fact that both the main accused in the case were not physically present when the riots broke out in the capital 5 years back. It mentions about the speech, the controversial speech that Umar Khalid gave in Amravati, which many dubs it as a Gandhian speech that he gave. The court, in fact, has used the term that speech cannot be brushed aside only because he's in Amravati at that point of time. It also says that while it is true that Sharjeel Imam was arrested much before the riots broke out in January itself, he had already done which led to the riots. Remember, Sharjeel Imam was the one, according to the prosecution, who made provocative speeches not in one place but in several other parts of the country, including Gaya and also in Aligarh. His defense counsel said that if he has been arrested earlier, why was he now booked under the UAPA case? So the court has said that already things were very in trouble. The court also said that he had distributed 5,000 pamphlets, and the very fact that there were several WhatsApp groups of which they were members. The court also looked into a rather controversial part as to why that they did not in fact interacted with each other. The court said that they were present in all these WhatsApp groups and they were monitoring all the developments. The court also looked into the fact that the accused in this case were in direct touch with other accused, and they were in fact aware of the fact the riots will be taking place. And the point at when the riots broke out, they in fact had left the city knowing that the police will be investigating this case, and eventually when the police...
Thanks so much, Madhavdas, for joining us with a quick update as to what the courts have said. Let's quickly open this up to our guests now for discussion.
You're watching the News Hour at 10, debate number 1 on Times Now, Super Prime Time.
Let's take this across to our guests. RP Singh is national spokesperson of BJP. We have Ishkaran Bhandari, advocate of Supreme Court, joining us. Shahid Ali, advocate, is with us. And advocate Tala Rashidi, spokesperson, the Rashtriya Ulema Council, is with us. Tala Rashidi, coming to you first. This is what the High Court order has noted, and I'm reading from it. Prima facie, it appears the appellants were the first ones to act after the CAB was passed in early December 2019 by creating WhatsApp groups and distributing pamphlets in Muslim populated areas calling for protests and chakka jams. If they are on ground calling for blockade and disruption, how are they not associated with their case, or why should they not be seen as part of the larger conspiracy? Can you explain to us, Tala Rashidi?
Good evening, everyone. Shankar, the question is that why are we jumping to conclusions? The court has made some observation. The sad reality is that the bail has been denied after people who are in jail since last 5 years, and still they are denied bail, whereas the judicial jurisprudence says that bail is right and jail is exception. Now the thing is that we are not asking for acquittal. If you say that the observation that has been made by the Honorable High Court, these facts, these evidences, these proofs are going to come into place when the trial starts. The mockery here is that it's been more than 5 years and the trial has yet not been started. If the prosecution feels that they have enough evidence against them and they are sure that they are the accused, why don't they go ahead and start the trial and let the court of law do the judgment? If they are accused, they will be prosecuted and they will be punished as per the law of the land. The question here is that we are not asking for their acquittal. We are only asking for their bail, which is a fundamental right. Why are they not being given bail?
Sir, have you read the High Court order?
The High Court after such a long...
Mr. Rashadi, have you read the High Court order?
I have gone through a few points of the High Court order.
What does it say on bail versus jail? Are you aware what it says on bail versus jail?
I didn't go through that point. If you...
May I read it out for you for the kind information of yourself and our lawyers? And I would assume as a lawyer you would have at least read the court order before coming on such a discussion. Nevertheless, it is tried law that grant of bail is the rule and refusal is the exception. However, the exercise of such discretion will depend on the facts and circumstances of each case. No single circumstance alone can serve as a universal yardstick to grant or refuse bail to an individual. 21. When it comes to special statutes such as the UAPA, the PMLA, the MACOCA, the courts, while adjudicating the bail applications for offences under such special statutes, are required to take into consideration the specific provisions governing bail thereunder. It's very clearly written in this order, sir.
So what? What is the point that you are trying to put forward here?
That it is not a universal rule as you are claiming to be.
There's no
that there are special statutes and those laws will govern such cases.
Yes, Madhav, there's no basic rule, universal rule in court. That's the discretion of the Honorable Court that if they find it suitable to give bail, they would go ahead and give bail. But as I said, there's a basic judicial jurisprudence when certain parity is followed. There are 3 people in the same case, those have been granted bail. Now they were demanding the bail on the basis of the parity and with certain points that their advocates put forward. As I said again, the universal jurisprudence is that...
What are the points? Tell us, what are the points?
I'll have to go through the file. If you have time, I'll just let you know the
Mr. Tala Rashidi, you neither know the arguments in this case, nor have you read the order. I don't know why you're coming into a debate poorly prepared. But nevertheless, Ishkaran Bhandari, 1 second. No, this is not the way to debate, sir. Ishkaran Bhandari, the point being made by opposition is very simple. They have raised the point of bail versus jail, and there are those who are saying, and I'm quoting one of the opposition leaders, Priyanka Chaturvedi, she says, keeping them behind bars for 5 years without bail is a pathetic reflection of the rot in our judicial system. Bail is a rule, jail an exception. If he's been in custody for 5 years without trial beginning, isn't that a violation of fundamental rights? Your response to that? Ishkaran. This is absolute ignorance of law which applies in such cases. But before I come to that, it's a 133-page judgment, but people who want to read should read page number 64 to 72. Just 6-7 pages, you will understand what was Umar Khalid, what was Sharjeel Imam's role, and that's spelled out. Second aspect, Madhav, before coming to the cases, it's very unfortunate that certain people on social media are directly, indirectly attacking the judges. It was a division bench of the finest judges, not only in Delhi, but in the country, who went strictly as per the facts, the evidence, and applicable law. So stop this practice of attacking judges. They cannot defend themselves, but their judgment speaks for itself, and it's very clear. And I'll come on the judgment now. So stop this practice of attacking judges. The fact is, just one paragraph, 122. What was the plan? They were the mastermind, Sharjeel Imam and Umar Khalid, where he says, Friday night को हल्का फुल्का वायलेंस हुआ था, मेरा भी चश्मा टूटा था, लेकिन हमें दिल्ली बंद करनी चाहिए कि अवाम को इनकन्वीनियंस हो. मैं पहले भी शायद अर्ज कर चुका हूं, 5 लाख लोग हमारे पास हों, ऑर्गेनाइज्ड हों, तो हम हिंदुस्तान और नॉर्थ ईस्ट को परमानेंटली कट कर सकते हैं. This is a man trying to cut northeast from India. We know the problems on our border. We know people who are giving a roadmap to other Muslims, distributing it in sensitive areas, as has come out in the judgment, and want to divide India. What is criminal offense if not this, where you have an actionable plan? The second aspect of this is WhatsApp groups have been cheated, and there are witnesses who have come out who have given testimony as to what was the role, how they were trying to incite students in colleges. Read paragraph 115, read paragraph 123, where they are making speeches giving roadmaps of how to destroy India. अगर भाई बिहार को डिटेंशन कैंप बनाया तो क्या कीजिए, जाके जलाइएगा कि नहीं उसको. You're talking about burning, you're talking about detention camps, you're talking about breaking, separating Northeast from India, and then you come here and say what was it done, why the courts have done this, what is the evidence? The evidence is writ large. Now the second aspect, where people say they have spent time in jail, it has come out in judgment, and before that also Nupur Sharma and Op India has documented how accused themselves were taking time. If you refuse to argue your case, if you do move application after application with the purpose to delay the trial, then can you take benefit of your own action? Okay. Of course you cannot take benefit of your own action. Several points that is what has come out. But several points you made. Let's get a response. Let's get a response, please. You made 2 or 3 important points.
As per the law of the land.
Yeah, because I don't want to get lost, because there are several important arguments that you have made. I want to bring in Shahid Ali on at least 2 of those points. One, what these people are accused of, particularly, this individual called Sharjeel Imam, he's threatening to cut off a portion of India. And more recently, we've seen, people outside of India, people inimical to India's interest, repeating that kind of chicken necks being cut off claim. You would also recollect, Shahid Ali, the importance of making such a charge. Point number 2 is the entire argument of the case being adjourned multiple times, even in Supreme Court. Adjourned 14 times. We've seen how even the former Chief Justice of India, Mr. Chandrachud, has stated, and I'm quoting him, can you imagine the case was adjourned? There were at least 7, if not more, adjournments which was sought by the counsel appearing for Umar Khalid. So how can the supporters of Umar Khalid blame the delays of the judicial system if his own lawyers were repeatedly seeking adjournments? Is a question that is being posed here by Ishkaran Bhandari. Shahid Ali.
Madhavan, there are differences between the material and evidences. Mr. Ishkaran just right now has read some excerpts from the judgment denying the bail, and he said that there are the evidences. So there is difference between evidence and the material. There is the material on record. Material has to be tested before the Honorable Court. Whether that material may be read as evidence or not, that will be decided by the court. So for that, fair trial is required. The trial, if the trial is delaying, then basically his fundamental rights are being delayed. His justice delayed is justice denied. This is a maxim, very important and very popular maxim, that justice delayed is justice denied. So as far as the adjournment,
it's material as to who is denying it. If you yourself are delaying your own case, seeking adjournments, then how are you blaming the system?
Bail is concerned, as far as the adjournment bail is concerned, it does not mean that he is not entitled for trial. Who stopped the prosecution from this the trial of the case? Nobody. They filed bail application, they took adjournment, okay. Now, who stopped the prosecution? Who stopped the state from proceeding further? As far as the trial is concerned, why no trials for last 5 years? So these two things cannot be equated. Undoubtedly, there is a discussion on honorable court. We have no the law is settled. There is discretion, and discretion has to be governed by certain judicial principles. Now, a particular person or particular judge has been defining or has been giving his own judgment on the basis of own experience. That is absolute different thing. But you say that there is no delay because the counsel of Umar Khalid had taken 7 adjournments on bail application. This absolutely is ridiculous. This is absolutely ridiculous because this was for the state to proceed with the trial. And so, as far as the present day is concerned, even the charges have not been framed. And the allegations are against...
Why is there been so much judicial delay? RP Singh would like to respond to the question of Shahid Ali. He says the adjournments have nothing to do with why the trial has not yet begun, why has the prosecution not begun it, why has the framing of charges not happened, so on and so forth. Respond to him. RP Singh.
Madhav, I'll come to that just after my point. The judgment also says, in fact, even the act preparatory to commission of terrorist act are punishable under section 18 of UAPA. Thus, the direction of appellate that case is not made out under a UAPA is based on assessing the degree of sufficient credible of evidence, not absence of its existence, but extent of its applicability. But such objections of appellant is outside the scope of ambit of section 43D. Bracket 5 under UAPA. Now, I'll read out another small part of the section 43D5. It categorically states restricts bail for accused individual under chapter 4 and 5 6 of the act, mandating them their bail to be denied if the court has found reasonable grounds to believe the accusation is prima facie true. Now, it's a court who has decided on this, and it has mentioned its observation that yes, prima facie there is a case, and he can't be let off. But there are people who are trying to stand by him because of the reason best known to them or for the political objectives of vote bank politics. Moha Machra or Priyanka Chaturvedi, and I mean they are trying to appease certain vote bank. They are doing it for certain vote bank. But this man has a history behind him. In 2016, he was booked under sedition for saying "Abjar hum sharminda hai," and after that 2020 the case was approved. In 2017 again he picked up a fight with the rival union, and against there's a case which was filed against him. 2018 he was booked under the provocative speech in Yalgar. So this man has a history. It's not that it's just one-off case. So court also sees the background of the person, and whether he is suitable to be given a bail or not is decided by court on basis of when he comes out, what will he do to the society? Is he a safe bet for society or not?
Respond to that, Shahid Ali. The court will look at it from the larger perspective of the background of the individual concerned. There are other cases, and therefore the court will take its decision. And also, may I also add another very important thing that's come out of this judgment. And I'm quoting. Just hear me out for a minute. This is what they have said. They have said similarly, appellant Umar Khalid also delivered speeches in Amravati on 17/2/2020 urging protests on 24th September 2020, which coincided with the state visit of the president of the USA, which is alleged by the prosecution to have deliberately been timed to cause violent riots on 23rd and 24th to garner international attention. The above role as assigned by the prosecution to the appellants cannot be lightly brushed aside. This is what High Court has said, and you would also recollect that famous Amravati speech that has been delivered by Umar Khalid.
Mr. Madhav, there are 3 books of law which are required to be read by everyone. Number 1, the Evidence Act. Now, saying something or putting forth as far as the speech part is concerned or any other material, if any other material also is placed before the court, that has to gone through the stage, particular stage, whether a particular piece of material may be read as evidence or not. There is law of evidence. There is a procedure as well prescribed in CRPC. Now, there are Honorable Supreme Court as well. The number of judgments on this point, the trial is delayed. And without trial, even in the murder cases where the imprisonment is up to life, the golden rule is that if a person is in custody for 10 years, even if their conviction has been upheld by the High Court, then also the sentence should be suspended. Now here it is a case wherein only are the allegations. Allegations may be in the form of speeches, allegation may be in the form of any other material, but that has not tested before the Honorable Court whether those evidence, those material may be read as evidences or not, are proved or not, whether the material put forth is true or not. Now, without doing anything, they have just denied him.
Cases like UAPA or Makoka charges.
The right to be released on bail. This is not the travesty of judgment. This justice. According to me, this is travesty of justice.
Respond to that. Ishwaran, respond to that. This is not the proper judicial process that has been carried out because these arguments, these evidences have not been tested before a court of law, says Shahid Ali. Your response to that?
These are materials, not evidences.
Madhav, it is said, Madhav, let us be very clear. It is a law of this land that yes, if the trial is being delayed extraordinarily, it becomes one of the grounds of bail. It is not as if because a trial is delayed, ipso facto you are deserving of a bail. Even after a conviction, it depends on case-to-case basis. What is the heinousness of the offense? What are the circumstances? What are the antecedents? A multiplicity of factors before a bail is given. And this was argued before the High Court that the trial has been going on for a long time and it's not going to conclude anytime soon. So please give bail. And the High Court has gone into this. Read the paragraphs where the High Court has gone into this and said these are special statutes, UPA, PMLA, for that matter NDPS, for that matter Makoka. And also, as I said, it has come out in the case. Can you benefit by delaying a trial yourself? That is also a question which have to be gone into. If your co-accused delay a trial because they are on bail, or if you yourself delay a trial because you are on bail, can you benefit by that? The court has gone into all that. Then also you have to understand one thing, that what was the heinousness of the offense, how large scale was the conspiracy. We are talking here people planning to separate Northeast from India. And we are talking as if that is all to be ignored and not gone into. And lastly, because again and again this is said emotively, 5 years in jail. How long did Sadhvi Pragya, how long did Colonel Prohit spend in jail who were later acquitted? This is not the case. They haven't been acquitted. I do not know what will happen tomorrow. Tomorrow they could be convicted. Tomorrow
respond to this. Respond to this. And Shahid Ali, and you can also come in on this, Tala Rashidi. This is what the court has said specifically on the entire issue of the delay in the trial. They have said grant of bail on the sole ground of long incarceration and delay in trial is not a universally applicable rule in all cases. They've also gone on to add that the probative value of evidence against Sharjeel Imam and Umar Khalid cannot be branded weak at this stage. Such assessment is premature. They've also added the alleged inflammatory and provocative speeches delivered by appellants, when considered in totality, prima facie indicates towards their role in the alleged conspiracy. These are very, very clear objections and arguments that have come in from the court side.
We respect judgment delivered by Honorable Court. Therefore, the Honorable Supreme Court is there to be this. Then the challenge will definitely be laid against this judgment. As far as the Ishkaran's statement is concerned, that really is very beautifully. He has said that if tomorrow he is this letter of, if tomorrow he is acquitted, then who is going to pay for this?
Okay.
His entire youth is going to remain behind bars.
All right. We'll have to leave it there, gentlemen.